have been asked to speak about the issue of mediation in the context of the 1980 Hague Convention regarding the matter of international child abduction. In recent years, we have seen mediation as a possible tool to be used by the parents and the courts to try and resolve these high conflict cases of child abduction. Mediation, if used in the context of abduction, it is important that the mediators have specialist knowledge of the convention, not only the international conventions, but the European regulations as well. Also, when considering mediation in such cases, we also have to ensure that the mediators are able to move quickly and speedily in line with the timeframes as set by the 1980 Convention, and also to ensure that there is a balance for these parents when entering mediation. What we do have to remember, first of all, is how will the attitude of the other country be if we were to mediate such a case? Are they expecting an automatic return of the child? Do they feel that it's appropriate for the parents to actually make the decisions going forward in the best interests of the child? Can we mediate in cases where one of the parents may be under the risk of criminal charges for child abduction? If that was the case, would there be a balance in the mediation process for those parents to actually enter mediation? What is the position of the parent that is the applicant parent? Can they say whether the criminal charges are going to go forward or not? Is it down to the police authorities of that state? Therefore, in the mediation setting, how could the mediators take it forward without having this information and knowledge? What is the position if the mediators were to consider working towards a voluntary return? Does the abducting parent have a right of entry back into the country of habitual residence of the child? Could it be that their immigration and visa status would stop them entering the country? Therefore, how could we mediate? We could not. Therefore, the screening process that is set up in any of these cases needs to be very specifically decided upon. For example, what are both parents wanting? If they are so polarised in their thoughts, can mediation actually bring them together to consider the best interests of the child? Would it be appropriate for the child's voice to be heard? Well, certainly under the 1980 Convention, we have to look at and consider the voice of the child depending on the age and maturity. When looking at the European regulations, under the Brussels II regulation, then all children's voices must be heard. How will the mediators hear that voice? Will it be through a mediator who is able to consult directly with children, or would it be an independent social worker? This would be depending on the directions of the court that is hearing the case. How do we look at the situation if the parents were to consider mediation where the child is going to live with one parent in one country and the other parent in another country? How can we work to ensure that the child maintains contact with both parents? Clearly, the main issue there is financial. Who will pay for this? This is very difficult for the parents to consider going forward. We have to consider that if one of the parents is going to be a primary carer and the other parent is going to be the visiting parent, what happens regarding child support? In some countries we see that child support is mandatory and it has to be paid. Therefore, the mediators would not be able to negotiate a lesser child support payment against the issue of costs for the child to visit the other parent in the other country. What's the position for the child when looking at the extended family? Grandparents, we know, play a vital role in children's life in many families. Mediation in the cases of international child abduction really have to be thought through. And one of the most important elements is actually the screening before going to mediation. We need to make sure that if these agreements are brought before the court and the parents have made a decision about where and whom the child is going to live with, the way that the agreement is written by the mediators, we have to ensure that they are very black and white and very clear, and that the court can actually seize those agreements and make them into consensual orders. We also have to consider as well how those agreements are going to be enforced in the other country. Following my recent attendance to the 6th Special Commission, one of the issues was how to enforce mediated agreements. And the Permanent Bureau and member states of the Convention were discussing the possibility of setting up an expert legal working group to consider this question and to see how we can strengthen the issue of mediation and enforcement of any mediated agreement to protect the child and to protect both parents. At International Family Law Group, we have a very specialist mediation service. I have been mediating in international child abduction cases covering both Hague and non-Hague for near on 12 years. We are able to monitor and evaluate the cases that we have undertaken to date, so we can learn from those previous cases and take that knowledge forward. We work very highly with the courts, particularly the high courts when dealing with these cases, to ensure that agreements are written in a way that the court can then make into consensual orders. There's been a lot of talk about the issue of jurisdiction. Who has jurisdiction? Should the mediation be taking place in the country of habitual residence of the child, or should it be taking place in the state to which the child is presently in? From a legal point of view, yes, this is a big question, but from a practical point of view, it hasn't been. And we have found in the mediation cases that we have undertaken is that there has not been an issue. The most important thing is for the parents to have lawyers in both countries, so that once the mediated agreements have been finalised through the court who is hearing the provisions under the 1980 Convention, that consensual order has been registered in the foreign jurisdiction before the child travels. There are many issues that we have to consider when mediating in international child abduction cases, but it is a way forward, and it is an extra tool to the mediators, and it is an extra tool to the courts to offer mediation in these high conflict cases. Also, how do we hear the voice of the child? As already mentioned, at IFLG, we now have mediators that can undertake direct consultation with children to ascertain the voice of the child in the mediation process. This is a great feather in our cap to be able to do this. And it also means that we can assist other legal firms and other mediation services to actually ascertain the voice of the child quite quickly, thus ensuring that the mediation takes place in the time frame as set down by the Convention, which is 6 weeks. We appreciate that some of the cases may be delayed by a few weeks, but we are very conscious that mediation must not be used as a delay tactic if we are going to use mediation positively in relation to the 1980 Hague Convention. We also see with the 1996 Convention, which is coming online now with many member states of the 1980 Convention, that the 96 Convention will certainly assist in the recognition and enforcement of mediated agreements. Therefore, my points that I would like to get over to anybody that is considering mediation in these types of cases is: number one, ensure that you have a proactive administrative system that can move swiftly and not hinder the time frame of the Convention. That the screening process for both parents is precise and set particularly to cover the issues that mediators would need to have the answers to before entering mediation, so to ensure there was a true balance between the parties when mediating. It is important that we have access to legal advice regarding the enforcement of orders. It is important that we understand the domestic law of the countries to which we are mediating, so we know that the things that we are agreeing with parents will be recognised and acknowledged in the other state. The worst thing we can do is offer mediation to parents in relation to the 1980 Convention by not using specialist mediators that understand the process. We also believe in these high conflict cases that it is important to have a co-mediation setting, therefore bringing different expertise to the table to ensure that we are making clear and precise decisions with the parents that will stand and hold up in a court of law. We have to remember when mediating these types of cases that we are going to change children's lives forever, and possibly their parents, on whom and where the children are going to live. We also see now that when looking at member states of the Convention, there is 20 plus countries now using mediation in the context of the 1980 Convention. We know that mediation will not work in every case, but it certainly works in a high percentage of cases. And for parents, it gives them an opportunity to stop, to think, to talk to each other, to consider the best interests of their children going forward. We have to remember that every family is unique. Every child's wishes and needs are unique. We can't have a blanket rule for these types of cases. So I believe that mediation can help a number of cases. It can't help all of them. But I believe that mediation should be offered to all parents who are dealing with international child abduction under the 1980 Hague Convention, to give them an opportunity to make the right decisions in the best interests of their children. If you require any further information regarding the specialist mediation service that we hold at International Family Law Group, Covent Garden, London, please do not hesitate to contact us, as we are always happy to share our experience, to share our knowledge with other mediators and other mediating services, and that of the judges that are hearing the cases, so to ensure that the right decision is being made in the best interests of children. Thank you.